Thank you for joining us. Starting one more time. Hi, thank you for joining us for another installment of the Erik Pelton Associates Trademark Law Monthly Teleconference. We are talking today about dilution law, a lesser-known form of trademark infringement that is becoming more and more important as the days go by. An issue of particular importance to small businesses, who are many of our clients. But first, before we get started, I'd like to introduce myself. And I'm Mark Donahue. I'm an associate attorney here, and with me is...
I'm Mike Melmer. I'm a law clerk here.
Yep, and this is Mike's second of these, and we're glad to be getting him involved in this. So just before we get started, as always, need to emphasize that this is not legal advice. I mean, we're giving general background about the trademark law. If you have a particular trademark issue, it's important to contact a trademark attorney. The specifics of your case are going to be very important in however it comes out. This is just kind of general background information. It's important to know it, but it's also important to get help from a professional who can give you specific advice to your specific situation. But so let's get started. Dilution. What is it? It's a form of trademark protection that's available only to the most famous marks, the very few marks that are well known, household names known to everyone in the country. And it's just those few, and it's a brand new sort of protection, really. Trademarks have been around for hundreds of years. Dilution law has only been codified in the federal law since the late 90s. It came into effect, I believe, in 1998. And you may ask, okay, we represent a lot of small businesses. If this is a form of protection that is only available to those with the most famous marks, why is it important for, say, a startup or a family-run business or a brand new business to learn about? And we'll get to that. The issue is, though you may not qualify for dilution protection, you need to know that others do, so that you don't accidentally run afoul of it. But so, in a nutshell, it protects incredibly well-known marks from uses by others of those marks on different goods, on a wider range of goods. So, for example, one of the better known, when people think of trademark infringement, they're generally thinking of what we call, it's generally done as a likelihood of confusion standard. And that is a more sort of narrow scope of protection. Maybe you could fill people in.
Yeah, likelihood of confusion is the protection that's available to all trademark holders, not just the most famous. All trademark owners, and that's more of a case where you're looking at whether or not consumers would actually be confused in the marketplace as to the source of the goods. So, in this case, the similarity of the marks is important, but also the similarity of the goods or the services you're offering under are extremely important.
Yeah, an example we always give is Delta faucets and Delta Airlines. If you see Delta on a faucet, you don't wonder if it's made by the same people who offer air travel, because, well, you don't really think of the two products and services being in the same industry at all. And so, that's a situation where likelihood of confusion would really never come up, because the products are different even though the marks are identical. Dilution, on the other hand, is a protection that's available even if the goods are very, very different. And so, let's give a hypothetical. Let's say that, instead of Delta faucets and Delta Airlines coexisting for a long time like they have, suppose that Delta Airlines started up long before Delta faucets and became incredibly famous among everyone in the United States, regardless of whether they were air travelers, among children and adults and men and women. suppose that they qualified for this very high threshold of dilution, and suppose that they qualified for it and became that famous before Delta Faucets even started. Under dilution law, the Delta Airlines could go and stop Delta Faucets from getting started, even though no one would be confused between the two. At least they'd have a decent argument for it. It's not rock solid, of course, and it's hard to prove dilution, but that's kind of the principle that makes dilution, I'd say, different than likelihood of confusion, is that it's not about whether someone's confused. You don't have to be confused. The goods don't have to be similar at all. It just has to be, I'd say, a similar mark, and a very, very, very famous mark. So I guess we can go into more on that. I mean, are there other contrasts with likelihood of confusion and standard infringement that you can think of? I mean, off the top of my head, the other thing is dilution protection only gives you whereas trademark infringement, say on a likelihood of confusion sort of basis, allows you to get an injunction to stop a use. There's also damages involved. Dilution only allows you to get an injunction, stop the use. And again, you've got to meet all of these other stringent requirements. But yeah, I mean, it's out there, and it's something a lot of business owners, small business owners in particular, it comes up a lot, where people don't know that this is also something they have to worry about. And so that brings us to why this is important. Obviously it's important for big businesses, because I think a lot of larger companies, whether or not they qualify for dilution yet, whether or not they're that tremendously famous mark, they're all trying to one day qualify for dilution. They're all trying to become that well known, and they're trying to position themselves to have this very strong, valuable protection for their brand. For smaller businesses, it becomes an issue because when you go to a trademark attorney or when you do a search on your own, and if you're only thinking about likelihood of confusion, if you're a plumber, you're going to go and you're going to see what other plumbers and related industries have your name. And so, it's something that is kind of a dangerous thing. If let's say, suppose Coca-Cola qualifies for dilution protection. They may not. It's something you have to be proved, but let's assume, just for this hypothetical, that they do. Suppose that you wanted to start Coca-Cola Plumbers. Now, you probably won't find a plumber called Coca-Cola, but you would get a call under a dilution theory from Coca-Cola's attorneys after you got started, and it's a rather expensive thing to start up a business and have to change your name, further on down the line. And you don't just have to worry about those who actually qualify for dilution. There's a lot of companies out there that feel like they ought to qualify for dilution. And so you might get calls from a lot of people who are using that as an additional ground for challenging your use. So on the one hand, it's very important for expanding your search, and on the other, it's very important for evaluating the claims others may make against you. You can't overlook the possibility that a company that maybe you haven't heard from is famous enough, or at least can convince a court that it's famous enough to really stand in the way and mount at least an expensive challenge to your right to continue in your name. And so, and I think this is something we see too much, where small businesses don't take that into account, and then run into problems when they get challenges later. And sometimes they're successful, but sometimes they aren't. And in all those cases, it results in a lot of money being spent trying to protect their right to continue using a name that they've invested in, sometimes years, when if they'd been aware of this possibility, in the future, they could have taken steps to avoid it in the first place, fair or not. But so, what exactly is the dilution test?
Okay, well, like you were saying earlier, there's basically three requirements you have to meet. First of all, you have to be like we were discussing earlier, you have to be extremely famous, the most famous of the famous, a household name, something everybody knows, and a name that everybody knows for the product that are sold under it. I mean, for a specific reason. And you have to prove that you had that fame before the person you're accusing of diluting your mark started using their mark at all. So this is not going to protect them. This is not going to protect a big company against someone who is using a similar mark before they got famous.
Right, and going back to the Delta Faucets, Delta Airlines example, presumably the faucet company was there. If Delta Airlines got famous enough, Delta Faucets was already using it maybe before it happened, or the other way around. Maybe Delta Faucets is famous, and Delta Airlines got started before Delta Faucets got famous, and so they have to coexist. They both seem fine with that. But.
And so, if you establish that your mark is famous and it achieved that fame before the alleged
junior user,
the
guy who
started
second.
using it, then the third thing you have to prove is that it actually is likely to dilute your mark. And under the law, there are two different ways that a mark can cause dilution. One is called dilution by blurring, which basically means impairing the distinctiveness. I think that Delta example would probably come under that umbrella. I mean, if that were a current situation.
If one of them were famous and the other one were just starting out. Yeah, I mean, it's one way blurring is characterized as like death by 1,000 cuts. So for example, I saw a great presentation by a trademark attorney who's been very active in this, and she used to work for Intel, and she this is Ann Gundelfinger, and she had a list of a whole bunch of examples, photographs of uses of the word Intel on various products that the Intel computer company was concerned about. It was tires, Intel brand tires and Intel brand hoses and Intel electricians and things like that. And I think from Intel's perspective, they claim that they're famous, and they probably spend a lot of money sending letters to these people telling them to stop, and they think, well, it's death by 1,000 cuts. They're worried that people are going to start seeing Intel all over for all sorts of products, and it's going to make their brand, I guess, less distinctive.
Another thing to point out that goes along with the Intel point is that your mark doesn't have to be famous. It doesn't have to be a made-up word or a coin term that you came up with. Right. Intel, for example, I mean, that's a word or it's an abbreviation for a real word. I mean, it has an accepted meaning before Intel started using it, but it is potentially
it's become, I'd say, well associated with the computer manufacturer, and then it's a matter to be decided by a court, whether or not they qualify for the dilution provision.
Yeah, but it doesn't have to be a made-up word in order to be famous. I mean,
right.
It can be a word out of the English language.
Though, would you be better off if you had a coin term?
I would assume so.
Yeah, I mean, if you had a coin term, if you had a made-up term, we'll say, Verizon or Singular or something like that, where you've invented the word for your mark, it would be pretty hard for somebody else to justify how they ended up branding another product with a made-up word and weren't trying to associate themselves with you. But that's true. If you're selecting a brand, it's a great idea to make up a word. But that's a topic for another one of these discussions, I think, that we've had maybe a couple months ago. So go ahead and look back at that one.
So like we said, the first way that a mark can dilute another mark is by blurring, but the other way is by tarnishment, which basically means that it's forming some association in the minds of consumers that harms the reputation of the famous mark. Mm-hmm. A lot of the cases where we've seen this, it's something where the junior user, the allegedly diluting mark, is somehow like adult services or something, sexual in nature.
Yeah. I mean, that would be, I guess, one of the, or something, something that a wholesome, famous brand would not like themselves to be associated with, I guess. which I guess is a peculiar thing because again, all this dilution laws predicate on the idea that you don't have that the consumer doesn't have to be confused.
Mm-hmm.
So the use that tarnishes the mark, even the person who sees the use apparently doesn't have to think that
There's any association.
yeah, it doesn't have to think
Yeah.
that Disney is selling, well, unsavory products or something like that. I mean, yeah, I mean, but you can see why a company would not want their brand associated with, well, lots of things.
Yeah.
But, so.
Well, another example of tarnishment was, I believe there was one case where a court held that the junior user wasn't marketing unsavory goods or anything like that, but they were marketing something that was considered of a lower standard, or they had
Mm-hmm.
less valuable warranty, or it was a lower quality of material or something. So that
Yeah. Okay. So.
the famous mark was tarnished by being associated with inferior quality.
Even if it wasn't confused with it.
Yes,
Yeah,
yeah.
just being associated with shoddy products, I suppose. Yeah. And so that's kind of the policy argument back and forth here with dilution is on the one hand you've got a company that has succeeded in creating tremendous goodwill for their brand, has made their brand a household name, and it's very easy to see how after having made that investment, they want their brand to be treated, with respect. I mean, they don't want it on, they don't want people to use it or associate it with things that may bring their brand into, a negative light. And they don't want to see their brand used on products that aren't theirs, whether or not people are confused. But on the other hand, the argument goes, well, if no one's confused, if no one actually thinks that the brand that someone other than Intel is selling hoses, then there's the argument on the other side is like, well, why not? And what's wrong with someone selling Intel hoses? This is a policy issue that's being argued, back and forth, and a lot of people have a lot of different opinions. But I think the practical lesson to take away, particularly if you're starting out and you're selecting a brand, is don't just look at the universe of competitors, the people who have products that are closely similar to yours, to determine, in your search, to determine whether or not you're going to have a right to use your mark. Look beyond that and look at other products and other well-known brands, and avoiding both likelihood of confusion and dilution, you can ensure that your investment in your own brand will be secure, and that you will not have one of these cease and desist letters coming to your door, and you won't have to fight off one of these very expensive claims, whether or not it's legitimate. So, yeah, So in conclusion, thank you for joining us. Next month, and again, we do this every month. Our topic is going to be international trademark protection. If you have any particular questions, or if you'd like to speak to us about a particular matter, or just see more of these talks, we're available at erikpelton.com. That's ERIKPELTON.com. We just redesigned the website. We hope you'll take a look. And we're also on Twitter, on our iPelton blog, and we're all over the web. And again, what you've heard today is not legal advice, but we hope that we've helped shed some light on some things in trademark law. But you should certainly contact the trademark attorney if you've got a specific question. And finally, this presentation is copyright 2011, Erik M. Pelton Associates, PLLC. And thanks, and hope you enjoyed watching.